Hello, my name is Andrew Flushy, and I'm your Virginia DUI attorney. If you're charged with a second offense DUI in Virginia, we need to look at the first offense to see if it really was a DUI that the Commonwealth can use against you. If it's an out-of-state prior, there's even better arguments that we can use. Even for Virginia cases, there's still things that we can argue depending on the circumstances. In a recent case, I had an Indiana prior that I had to deal with. Now, every case depends upon the facts and circumstances of each case, and past results don't predict future success. However, in this Indiana prior situation, I was able to convince the prosecutor that the Indiana prior should not count against my client. Where my client had been charged with a second offense DUI where he was facing mandatory jail time, we were able to convince the prosecutor that this was really just a first offense by law in Virginia, and my client served no active jail time. That's a win in any book. So the Indiana prior, the issue is that the statute in Indiana is much more broad than Virginia's DUI statute. In Virginia, you have to actually be driving something with an engine in order to get a DUI. So it has to have a motor vehicle, an engine, or a train is what Virginia DUI covers. And you don't necessarily have to be driving, you have to be operating. That's a pretty broad category, which basically means you're usually behind the wheel of the car in some fashion. However, in Indiana, the law covers any device for transportation by land or air, which could mean anything that a person could be transported on. It could mean a little red wagon, it could mean a bicycle, it could mean a scooter, it could mean something with a motor, but it doesn't have to be powered by a motor or an engine in Indiana. So you could get a DUI on a bicycle there, whereas you cannot get a DUI on a bicycle in Virginia. So because the Indiana law was more broad than Virginia's law, which is pretty broad but a little more narrow than Indiana, they couldn't prove beyond a reasonable doubt that that prior was really something that was similar enough to Virginia law. And because of that, the prosecutor agreed to amend the charge to a first offense and have no active jail time for my client. As you can see, looking into these legal issues and having an attorney who's familiar with arguing these issues is critical for your case. Not only can it eliminate active mandatory jail time, but it can also save your license. For a second offense DUI in Virginia, the law requires 3-year suspension of your driver's license, and you can't get a restricted license right away. However, if we can beat the prior and make it a first offense, it's a 1-year suspension of your license, and you can get a restricted license usually right away. So contact me today if you're charged with DUI in Virginia so we can discuss the facts of your case, and if it's a case where it's charged as a second offense, we definitely want to look into the prior and get started right away researching how we can try to fight the prior offense.